Good morning. I hereby call to order the sixth meeting of the Pennsylvania Public Utility Commission for the year 2023. I welcome everyone that is here with us in person as well as those that are watching us on our live stream. And now I ask you to please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic which it stands, one nation, under God, indivisible, with liberty and justice for all. So today's meeting, as always, it is open to the public, and we will act on various matters. I will note that there's no opportunity for the public to address the commission at the public meetings. Public meeting motions, statements, and video will be available on the commission's website later today. So our first matter for consideration on this morning's agenda is the approval of the minutes for March 16, 2023, and I turn to Vice Chairman DeFrank, who is the editor.
Thank you, Madam Chair. I've reviewed the minutes of the public meeting of March 16, 2023, and move that they be approved as submitted.
You've heard the motion to approve the minutes. Is there a second?
Second.
Second by Commissioner Yonora. Any further discussion or edits? Hearing none. On the adoption of the minutes, all those in favor, please say aye.
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 Any opposed? The minutes are approved 5-0. And at this time, we will then turn it over to our Secretary of the Commission, Rosemary Chiavetta, to lead us through this morning's agenda.
Good morning, Madam Chairman. Good morning, Commissioners. Your various bureaus and offices have prepared the following agenda for your consideration. Therefore, let us begin on page 1 with the recommendation of Director Monahan and the Bureau of Audits that the Commission adopt the Management Efficiency Investigation Report and Implementation Plan of UGI Utilities Gas Division and release both to the public.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2, it is recommended by Acting Executive Director Cremola and the Office of Executive Director that the Commission adopt the proposed order appointing David Henning to fill the vacancy on the Damage Prevention Committee.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yonora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3, and matters presented by Director Sophie and the Office of Special Assistance, it is recommended that the Commission adopt in an omnibus motion both items on page 3, beginning with the secretarial letter issued to Tejoma Incorporated TA Exclusive Destinations Services and ending the omnibus with the application filed by the Norfolk Southern Railway Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Zerfis, second by Vice Chairman DeFrank. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 4. It should be noted that the first item on page 4, the investigation of the Bureau of Investigation and Enforcement versus Great American Power, LLC, has been postponed to the public meeting of June 15th, 2023. Continuing on page 4, it is recommended that the Commission adopt in an omnibus motion the motion and petition for reconsideration filed in the matter of the Bureau of Investigation and Enforcement versus West Penn Utilities, LLC, and continuing the omnibus to include both items on page 5, both items on page 6, both items on page 7, both items on page 8, and ending the omnibus motion with the single item at the top of page 9, the application of Silverback Freight, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Yunora, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 10, and matters presented by Director Diskin and the Bureau of Technical Utility Services. It is recommended that the Commission adopt the proposed order regarding the application of the Pennsylvania American Water Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfis. Any discussion? I would like to state on the record for discussion that before joining my staff, James Mullins provided legal counsel on this matter as an assistant counsel in the Law Bureau. Please note that he has not advised me in this matter. Any further discussion? Seeing none, all those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Continuing on page 10, it is recommended that the Commission adopt in an omnibus motion the last item on page 10, the application of Acrobat Energy LLC, and continuing the omnibus to include both items on page 11, both items on page 12, both items on page 13, both items on page 14, both items on page 15, both items on page 16, and both items on page 17, ending the omnibus motion with the cancellation of certificates of certain motor carriers for failure to maintain evidence of insurance.
Is there a motion to adopt the staff recommendations?
So moved.
Motion by Commissioner Zerfis, second by Vice Chairman DeFrank. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 18, and matters presented by Acting Executive Deputy Chief Counsel Screven and the Law Bureau, it is recommended that the Commission adopt the proposed order in the petition for reconsideration filed by Vertigris Energy LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Continuing on page 18, it is recommended that the Commission adopt the proposed order in the Notice of Proposed Rulemaking regarding the Low Income Usage Reduction Program.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Zerfis, second by Vice Chairman DeFrank. Any discussion?
Madam Chair.
Commissioner Zerfis.
Madam Chair, Madam Secretary, I have a statement. Please add it to the public record. I will read it as if I'm reading in its entirety, and I'll try to summarize it. But before the Commission today is the Notice of Proposed Rulemaking, called a NOPR, that proposes amendments to our existing Low-Income Usage Reduction Program. As the LIURP regulations have not been amended since 1998, now seems like the appropriate time to revisit based on the knowledge and experience this Commission, public utilities, customers, and our vested partners have gained over the years. For those unfamiliar with LIURP, it is simply put a program sponsored by electric and natural gas public utilities that provides weatherization and energy usage reduction services to help low-income customers. The utilities' LIURPs are significant programs because consumers can see positive impacts in a variety of ways, such as an energy savings, bill reduction, improved payment behavior, reduced use of supplemental fuels and secondary heating devices, more affordable low-income housing, reduction in homelessness, and less housing abandonment. For their LIURPs, electric utilities completed 14,176 jobs in 2021 alone, and natural gas utilities completed 3,091 jobs in 2021 alone to assist low-income customers. I would like to commend the Law Bureau and the Bureau of Consumer Services for their diligent work in creating such a comprehensive regulatory package, as well as many of the commenters whose views enrich these proposed amendments. These comprehensive proposed amendments contain numerous customer benefits, as well as various coordinated and streamlined processes that will assist low-income customers in enrolling in energy reduction programs and enhancing the efficiencies of these programs. Just as some examples of what these might be, of these beneficial proposed amendments: it would require a public utilities LIERP to be designed and operated in conjunction with the public utilities' other universal service programs and public-private programs that provide energy assistance to the community. Consistent with this proposed amendment, a public utility shall directly or through an assigned third party assist LIERP participants in applying for energy assistance programs such as LIHEAP based on income eligibility. It requires a public utility to coordinate its LIERP services, trainings, outreach, and resources with other public utility LIERPs and with other energy assistance programs. It permits public utilities to increase the spending limit for special needs customers to 25% of the LIERP budget, to provide greater flexibility to serve more special needs customers who are ineligible for utilities customer assistance program, but may still need help with their utility bills. These proposed amendments are consistent with the Commission's recent interest in improving coordination and efficiencies within our public utilities universal service programs and maximizing the allocated dollars for these programs to the benefit of residential customers. As part of this proposed rulemaking process, I look forward to receiving comments from all interested parties during the public comment period. These comments will aid our consideration in crafting final regulations that continue to assist LIERP participants in decreasing energy usage and utility bills, which in turn will create cost savings and reduce uncollectible accounts, as well as improve the health, safety, and comfort levels for all recipient households. Thank you.
Thank you, Commissioner Zerfus. Any further comments or discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 19, it is recommended that the Commission adopt the proposed order regarding the motion and petition for reconsideration filed by Columbia Gas of Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? Second. Motion by Commissioner Yonora, second by Vice Chairman DeFrank. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Continuing on page 19, it is recommended that the Commission adopt the proposed order regarding the petition filed by Charge VC Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Coleman. Any discussion?
Madam Chair,
Vice Chairman DeFrank.
I have a joint statement with Commissioner Zerfus and ask that our statement be entered into the record as if I read it in its entirety. Before the Commission is the petition of Charge EVCPA requesting the initiation of a proceeding that would result in the issuance of a policy statement on electric utility rate design for electric vehicle charging in Pennsylvania. EV adoption continues to grow considerably in the Commonwealth, with 43,725 battery and 23,839 plug-in hybrid EVs registered as of March 2023, according to PennDOT. As well, incentives for both EVs and charging stations are continuing to be distributed right here in Pennsylvania from the federal government, from the Commonwealth itself, and a number of electric distribution companies. DEP has provided financial assistance to approximately 1,860 Level 2 charging plugs at over 500 locations in the Commonwealth since 2018, and to 32 direct current fast charging projects since 2019. Further, PennDOT received approval of its National Electric Vehicle Infrastructure Formula Program by the Federal Highway Administration in September of 2022. The NEVI program will disperse $171.5 million per year over 5 years, with an initial focus on DC fast charging stations and infrastructure located near highway corridors. This impending sea change in the transportation sector presents an opportunity for electric utilities, as increased consumption for EVs can work to defray traditional customer distribution system costs. However, this new consumption will have a unique demand profile, particularly from the DC fast charger stations. Therefore, it is incumbent on this commission and the regulated electric utility industry to consider and adopt rate structures that foster the most effective and equitable use of distribution grid to the benefit of all consumers. We believe the issuance of a policy statement can assist in properly aligning EV charging demand with distribution system cost of service. To this end, we are pleased to support the initiation of a proceeding to issue a policy statement on electric utility rate design for EV charging. Thank you, Madam Chair.
Thank you, Vice Chairman DeFrank. Any further comments or discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 20, it is recommended that the commission adopt the proposed order in the petition filed by the Borough of Weatherly seeking a declaratory order.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman DeFrank. Any discussion?
Madam Chairman,
Vice Chairman.
I have a statement. I ask that my statement be placed on the record as if I read it in its entirety. Before the commission is the petition of the Borough of Weatherly for a declaratory order. The petition seeks a determination that the borough's provision of electric service to 3 customer properties located beyond the municipal boundaries does not constitute public utility service subject to the commission's jurisdiction. In support of its petition, the borough stated that the 3 properties are located in a densely forested area within the service territory of PPL Electric Utilities. The borough indicated that PPL consented to the borough's provision of electric service to these properties. Additionally, the borough attached a copy of a resolution to its petition that was passed by Borough Council. The resolution affirms the borough's intentions to charge the same electric rates to customers inside and outside the borough's municipal limits, to not expand service to any customer other than the 3 customers described in its petition, and to not amend or repeal the resolution without providing prior written notice to the commission. The borough owns and operates a municipal electric system that provides electric service to approximately 1,131 customers located within the borough. The borough's proposed service to the 3 customers who are located outside of its municipal boundaries represent approximately 0.25%, 0.27% of its entire customer base. I recently dissented on a commission decision that found the municipality's provision of water service to 42 customers located outside of its municipal boundaries was not jurisdictional public utility service. In that matter, 13% of the municipality's entire customer base was located outside of the municipal limits. I found that the Public Utility Code does not contemplate such a wide exception to the requirement that municipal corporations obtain commission authority prior to furnishing public utility service beyond their limits. Here, however, I find that the small percentage of customers located outside of the borough, approximately 0.25%, as well as the limitations set forth in the borough's resolution, are sufficient to find that the borough is not providing electric service to the general public and therefore is not subject to the commission's jurisdiction. Thank you, Madam Chairman.
Thank you, Vice Chairman DeFrank. Any further comments or discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Continuing at the bottom of page 20, it is recommended that the commission adopt the proposed ratification of the emergency order signed by Vice Chairman DeFrank on April 28, 2023, in which the Philadelphia Gas Works requested to revise and amend its weather normalization adjustment clause.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman DeFrank, second by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? Motion passes 5-0.
Turning to page 21, in matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt the initial decision of A.L.J. Buckley in the formal complaint of Ronald Baroni versus the PECO Energy Company Electric Division.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Zerfus, second by Vice Chairman DeFrank. Any discussion?
Madam Chair.
Commissioner Zerfus.
Madam Chair, Madam Secretary, I have a motion in this matter, and I will read it as if I'm reading it in its entirety, but I will try to be brief. On May 13, 2022, Ronald Baroni filed a formal complaint alleging that PICO Energy Company refused to accept a medical certification for his son and was threatening to terminate his electric service. For relief, the complainant requested that PICO be required to accept the medical certification and that the commission establish a payment arrangement for him. On June 1, 2022, PICO filed an answer and new matter denying that the complainant is legally entitled to a commission-ordered payment arrangement and stating that PICO has accepted medical certifications from the complainant, but the complainant has not made payments on his current bills. On September 27, 2022, a hearing notice and a pre-hearing order were sent by electronic email to the email address the complainant provided on his complaint form. The hearing convened as scheduled. Counsel for PICO appeared with one witness, however, the complainant did not. Thereafter, the issue was dismissed with prejudice. I submit that the practice of dismissing complaints filed by pro se complainants with prejudice when there is no record of the complainant agreeing to service by email and the complainant fails to appear at the hearing is inconsistent with due process. There is no need to close the door to this venue to pro se complainants unless record evidence shows that they are abusing the Commission's administrative processes to avoid paying their utility bills. And here, there is no evidence of this abuse of administrative process. Under the circumstances involving the complainant's pro se status and his lack of affirmative agreement to service of his email address, I move that the initial decision of Administrative Law Judge Dennis Buckley, issued on March 21st, 2023, is modified consistent with this motion. That the complainant be provided an opportunity to file a written request for an evidentiary hearing within 20 days of the entry of her order in this matter. That if a written request for an evidentiary hearing is timely filed, the proceeding shall be remanded to the Office of Administrative Law Judge for further proceedings as warranted and for the issuance of an initial decision on remand. That if a written request for an evidentiary hearing is not timely filed, the complainant shall be dismissed without further action by the Commission. And that the Office of Special Assistants prepare an order consistent with this motion. And that the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Thank you.
You have heard the motion of Commissioner Zerfus. Is there a second?
Second.
Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, Commissioner Yenor and I have a joint statement.
Commissioner Coleman.
Thank you. For those of you that were with us last public meeting, maybe you realize, as I did this morning when I woke up, that this is our Groundhog Day event. This is the same issue that we had discussed in extensive detail at last public meeting. Over 11 cases, and this morning we have 3 more, and perhaps we'll have more into the future. The basis for this motion, as you've heard, is alleging that this commission has erred in its way of serving pro se complainants by doing so electronically without their consent. And as we indicated at last public meeting, that the 3 commissioners, Chairman Dutrell, Commissioner Yenor, and myself, had unanimously approved waiver of regulations of this commission on 2 occasions. And that's the period of time in which we're talking that these allegations of violation of due process occurred. I'm not going to belabor the point here this morning, and I appreciate your indulgence, but I do have one message that I just want to, again, reiterate this morning, and that is to the team of this commission. And I just want to make sure that it is very clearly stated that this team did as this commission and commissioners instructed them to do. We as commissioners took the appropriate action as counseled by our chief counsel, Rick Hicks, and we directed the staff to proceed accordingly and to use electronic means to keep this commission operating. And I stand by that, and I just want this team to know that this is not on them. This is a decision and a sea change here at this bench, and it rests with us, not with the team. The integrity of our team members is fully intact, and the integrity of this commission remains intact. And so it's unfortunate that we're here again this morning, but I understand the reality of the world that we're in today. With that being said, I'm going to ask that the joint statement of Commissioner Yonora and myself be entered in the record as though it was read in its entirety. And let me just simply state that the statement is identical to those that were entered into the record of the public meeting of April 20th, 2023, for those cases that involve the same issues as raised by this motion. We conclude that the complainants were afforded adequate notice and opportunity to be heard, and that the Commission's actions were consistent with applicable orders and permitted the service of documents via electronic mail, and that the initial decision should be adopted without modification. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further discussion on the motion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed?
Nay?
Nay.
The motion passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Yonora. On the matter as amended, is there any objection to taking the previous roll call? Seeing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Yonora.
Continuing on page 21, it is recommended that the Commission adopt the initial decision of ALJ Hoyer in the formal complaint of Daniel Lloyd and Indian Head Development, LLC versus the Duquesne Light Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Yonora, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0.
Turning to page 22, it is recommended that the Commission adopt the initial decision of ALJ Chiodo in the formal complaint of Angela F. Dennis versus the Metropolitan Edison Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Zerfis, second by Vice Chairman DeFrank. Any discussion?
Madam Chair.
Commissioner Zerfis.
Madam Chair, Madam Secretary, I have a motion in this matter. I will read it as if I'm reading it in its entirety, but I will try to be brief. But on August 3rd, 2022, Angela Dennis filed a formal complaint alleging that Metropolitan Edison Company, called the MedEd, had threatened to terminate her electric service and that there were incorrect charges on her bill and that she would like a commission-issued payment arrangement. In its answer in new matter, MedEd admitted and denied various averments raised by the complainant, not only addressing the complainant's account status, but also her allegations that she did not enroll with 3 different electric generation suppliers, her claims regarding charges associated with that supply, and her claim of shared metering. MedEd requested that the complaint be dismissed with prejudice or denied in its entirety. On November 7th, 2022, a hearing notice was sent by email to the email address the complainant provided on her complaint form. Thereafter, a notice of judge change and pre-hearing order providing the date and time of the hearing were sent by email to Ms. Dennis. The hearing convened as scheduled. Counsel for MedEd appeared with 1 witness. However, the complainant did not. Thereafter, the issue was dismissed with prejudice. I submit that the practice of dismissing complaints filed by pro se complainants with prejudice when there is no record of the complainant agreeing to service by email and the complainant fails to appear at the hearing is inconsistent with due process. Under the circumstances involving Ms. Dennis's pro se status and her lack of affirmative agreement to service to her email address, I submit it is in the public interest to afford her an opportunity for an evidentiary hearing. But there are additional factors that bode in favor of further evidentiary proceedings in this matter. This issue is distinguishable than the last. So more specifically, the complainant contended that she did not sign up with 3 EGSs identified on her complaint form, Smart Energy, WGL, and Clean Choice, and discussed at length by it was discussed at length by MedEd in its new matter. The Commission takes these allegations of slamming very seriously and finds that affording the EGS's due process is also imperative. These EGSs were not even joined as indispensable parties to respond to the affairments regarding whether the complainant signed up for their service and whether the charges reflected on her account are correct. So it is clear, based on a reading of Ms. Dennis's complaint, that the 3 EGSs should have been joined as indispensable parties in this matter, because at least some of the charges of which Ms. Dennis complains of are charges from those suppliers. Clearly, Ms. Dennis specifically denied signing up with these EGSs and challenged the charges. As a result, it is appropriate in this matter to remand back to the OALJ, where the EGSs should be joined as indispensable parties in a hearing held regarding whether Ms. Dennis signed up for their services and whether there are incorrect charges on her bill. To be clear, these issues are in addition to Ms. Dennis's other assertions of shared metering and her request for a payment arrangement. So therefore, I move that the initial decision of Administrative Law Judge Gail Kyoto, issued on February 21st, 2023, is vacated consistent with this motion. This matter is remanded to the Office of Administrative Law Judge for further proceedings. That Smart Energy, WGL, and Clean Choice be joined as indispensable parties to this proceeding and given all notice and opportunity to be heard. That a further evidentiary hearing be held on all of the issues identified in Ms. Dennis's formal complaint. That the Office of Special Assistants prepare an order consistent with this motion, and that the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Thank you.
You have heard the motion of Commissioner Zerfus. Is there a second? Second. Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, Commissioner Unor and myself have a joint statement.
Commissioner Coleman.
Thank you. And I just briefly ask that the joint statement be entered into the record as though we read it in entirety. This is similar to my last statement. Thank you.
Thank you. Any further comments or discussion? Hearing none on the motion. All those in favor, please say aye.
Aye.
Any opposed, please say no.
Nope.
Nope.
The motion passes 3-2, noting the dissent of Commissioner Unor and Commissioner Coleman. On the matter as amended, is any further discussion or is there any objection to taking the previous roll call? Seeing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Unora.
Continuing on page 22, it should be noted that the initial decision of ALJ Coogan in the formal complaint of Annie Matkowski versus the Pennsylvania Electric Company has been postponed to the public meeting of June 15, 2023. Turning to page 23, it is recommended that the Commission adopt the initial decision of Special Agent Maroxa in the formal complaint of Darlo Bongiorni versus the West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman DeFrank. Any discussion?
Madam Chairman,
Vice Chairman.
I have a motion on the matter and ask that the motion be entered into the record as if I read it in its entirety. Before the Commission for consideration is the initial decision issued on March 16, 2023, which dismisses the formal complaint filed by Ms. Darlo Bongiorni. The initial decision declines to grant a payment arrangement, reasoning that the complainant is likely to default. By way of background, Ms. Bongiorni filed a complaint on September 6, 2022, requesting a Commission-approved payment arrangement in an amount less than the payment arrangement amount that BCS granted. During the hearing, the complainant testified that she does not use gas service to heat her home because her gas furnace is not working properly due to carbon monoxide issues. Instead, the complainant uses 5 space heaters and a stove. The use of these appliances for home heating resulted in increased electric usage. At the time of the hearing, the complainant's balance with West Penn Power was over $1,600. She maintained that she is unable to afford the monthly budget billing amount of $204. She also indicated that she anticipated that her furnace would be repaired shortly. Consistent with recent Commission precedent, I submit this motion to amend the initial decision. The complainant was eligible for a Commission-issued payment arrangement, yet one was not awarded. I am not discounting the record evidence that the complainant expressed an inability to pay the monthly budget bill amount, and that a level 1 payment arrangement would add approximately $27 to the monthly budget bill. However, as the complainant has not defaulted on a commission-approved payment arrangement, she should be afforded the opportunity to pay down the arrearage over the applicable number of months in accordance with Section 1405 of the Public Utility Code. Otherwise, West Penn Power could require the complainant to pay her total outstanding balance at once to avoid termination of electric service. Thus, this motion seeks to ensure that the complainant is afforded a payment arrangement opportunity like similarly situated ratepayers with arrears on utility balances. Since the complainant's gross monthly household income does not exceed 150% of the federal poverty level for a household size of 1, she is eligible for a 5-year payment arrangement to address her outstanding balance. Therefore, beginning with the first bill following the Commission's final order in this case, the complainant is required to pay her current bill plus an amount equal to 1/60th of the balance accrued on her account. I caution the complainant to adhere to this payment arrangement because it is the best arrangement the Commission can grant under Chapter 14. I also anticipate West Penn timely utilizing all available collection methods if the complainant fails to adhere to the payment arrangement. Additionally, to the extent that the complainant is served by Peoples Natural Gas and has not yet corrected the carbon monoxide issue with her furnace, I encourage her to contact Peoples to determine her eligibility for any customer assistance programs that may aid in the repair of her furnace. Weatherization programs are available to qualified income-challenged applicants to address situations such as these and to avoid the use of dangerous heating alternatives like space heaters. Therefore, I move that 1, the initial decision dated March 16, 2023 is amended to grant complainant's request for a payment arrangement. 2, complainant shall make monthly payments consisting of her current bill plus 1/60th of the balance accrued on her account, beginning with the first billing due date following the entry of this final commission order in this case. 3, as long as the complainant keeps the payment schedule stated herein, West Penn Power Company shall not suspend or terminate utility service except for valid safety or emergency reasons, or assess late payment or finance charges against her account. 4, if the complainant does not keep the payment schedule stated herein, West Penn Power is authorized to suspend or terminate her utility service in accordance with the Public Utility Code and Commission regulations. And 5, that the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you, Madam Chairman.
Thank you, Vice Chairman. You have heard the motion of Vice Chairman DeFrank. Is there a second?
Second.
Second by Commissioner Yenora. Any discussion on the motion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 5-0. On the matter as amended, is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 5-0.
Continuing on page 23, it is recommended that the Commission adopt the initial decision of ALJ Gould in the formal complaint of Robert Adams versus the Philadelphia Gas Works.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second? Second. Motion by Commissioner Zerfus, second by Vice Chairman DeFrank. Any discussion?
Madam Chair.
Commissioner Zerfus.
Madam Chair, Madam Secretary, I have a motion in this matter. I will read it as if I'm reading it in its entirety, but I will try to be brief. On September 6, 2022, Robert Adams filed a formal complaint alleging that Philadelphia Gas Works, PGW, was threatening to terminate service and that there were incorrect charges on his bill. For relief, the complainant requested a reasonable payment agreement. PGW filed an answer denying the material allegations of the complainant. On October 7, 2022, a notice of a telephonic hearing was sent by email to the email address the complainant provided on his complaint form. Thereafter, a pre-hearing order was sent by email. The hearing was convened as scheduled. Counsel for PGW appeared with one witness. However, the complainant did not. Thereafter, the issue was dismissed with prejudice. So similar to the previous Baroni matter, I therefore move that the initial decision of Administrative Law Judge Marta Gould, issued on April 11, 2023, is modified consistent with this motion. That the complainant be provided an opportunity to file a written request for an evidentiary hearing within 20 days of the entry of her order in this matter. that if a written request for an evidentiary hearing is timely filed, the proceeding shall be remanded to the Office of Administrative Law Judge for further proceedings as warranted and for the issuance of an initial decision on remand. That if a written request for an evidentiary hearing is not timely filed, the complaint shall be dismissed without further action of the Commission. That the Office of Special Assistants prepare an order consistent with this motion. That the Secretary's Bureau serve a copy of the order on the complainant by certified mail. Thank you.
You have heard the motion of Commissioner Zerfus. Is there a second?
Second.
Second by Vice Chairman DeFrank. Any discussion on the motion?
Chairman, Commissioner Yenor and I have a joint statement on this matter.
Commissioner Coleman.
Thank you. And again, this is similar to the discussion earlier. I just asked that our joint statement be added to the record as though we had read it in its entirety. Thank you.
Thank you, Commissioner Coleman. Any further discussion? On the motion, all those in favor, please say aye.
Aye.
Aye. Any opposed, please say no.
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 The motion passes 3-2, noting the dissent of Commissioner Coleman. Commissioner Yenora. On the matter as amended, is there any objection to taking a previous roll call? Seeing no objection or hearing no objection to taking a previous roll call, the matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Yenora.
Madam Chairman, that concludes regular agenda. Turning now to the carry-in agenda. On page 1 of the carry-in, it is recommended by the Office of Special Assistants that the Commission adopt the proposed opinion and order regarding the weather normalization adjustment rate of the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Zerfus, second by Vice Chairman DeFrank. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed, please say no. The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all agenda items for consideration today.
Thank you very much, Madam Secretary. Before we adjourn today's meeting, I would like to recognize a couple of my colleagues for remarks. First, recognizing Commissioner Yenora for remarks.
Thank you, Madam Chair. Last week, we celebrated Drinking Water Week, which is part of an ongoing effort to increase awareness about safe drinking water across the Commonwealth. In recognition of Drinking Water Week, the Commission renews its commitment to address challenges facing public water supplies with a focus on protecting treated drinking water from contaminants. We work with customers, regulated water utilities, and our sister agencies to realize the public health goals of the Federal Safe Drinking Water Act of 1974 and the Pennsylvania Safe Drinking Water Act of 1984. The Commission's most recent efforts, including rulemakings to address the replacement of metallic lead line service lines and adopting a uniform water audit methodology, as well as a policy statement proposing best practice for public and private fire protection. The Commission expects finalization of rulemakings and policy statements in the near future. Thank you.
Thank you, Commissioner Yenora. I now recognize Vice Chairman DeFrank.
Thank you, Madam Chairman. The month of May is Electric Safety Month, and I wanted to take a few moments to emphasize the importance of awareness, communication, and planning when working near power lines. This is a busy time of the year for construction work and other outdoor projects, which makes this potentially hazardous time for homeowners, workers, and contractors. According to the PUC Safety Division, there were 19 incidents last year involving accidental contact with electrical lines, resulting in 1 death and numerous serious injuries. Over 80% of those accidents occurred during spring and summer, so this is clearly the high-risk season. Equally important is that nearly all of those incidents were preventable. Awareness can be a lifesaver. Always take time to determine the location and safe distance of all power lines. Communicate with your local utility for information about making the area around power lines safer. And plan your work carefully, remembering that power lines may be above, behind, beside, or underneath you. If you're planning a project around power lines, we encourage you to visit the electric safety page of the PUC website and also contact the local utility company before starting work. It only takes a single moment of misjudgment or distraction when working near power lines to result in tragedy. So please take some extra time before starting any project to be sure you are working as safely as possible. Thank you, Madam Chairman.
Thank you, Vice Chairman DeFrank. I also want to take a moment to recognize May as Asian Pacific American Heritage Month. The Multi-Agency Planning Committee will once again hold a virtual program on May 31st, starting at 12 noon. This year's national theme is Advancing Leaders Through Collaboration. To register to attend this event, please visit the PUC's website at puc.pa.gov. And finally, I'd like to close out with taking a moment for us to focus on our Memorial Day remembrance, which we will recognize in about 11 days. Let us take time this Memorial Day as a time for us as a nation to express our gratitude for the unthinkable sacrifices made by servicemen and women, risking their lives for the safety of our country and its ideas. As we all enjoy the long weekend, please remember the reason we celebrate Memorial Day and the sacrifices of others. On behalf of my fellow commissioners, I wish everyone a healthy and safe Memorial Day weekend. So thank you for joining us for today's PUC's Public Utility meeting, and I will take a motion to adjourn.
So moved.
Is there a motion by Commissioner Unor? Is there a second by Vice Chairman DeFrank? All those in favor of adjourning, please say aye.
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 I'm sure there's no opposed, but the motion passes 5-0. We are adjourned. Thank you, everyone.